you know being a wife does not give you the right to bury? Is this dispute of burial only in Africa? So the law is developing. You might be the wife. You might be the brother. You might be the father. You might be the mother. The deceased is your son. But you are practically incapable. Is it lawful to keep somebody in a mortuary for 5-7 years? This is a landmark ruling. Welcome to Court Helicopter Explainer. We are dealing with when you are dead. How will your body be buried? Last week, we brought a very controversial matter, the SM Otieno burial, where culture versus a wife, the culture won and the wife lost. Wamboyo Otieno lost and the Omiraka girl won. Those were 20-30 years ago. What is the actual law today? Because the law has changed. The law has improved. So today we bring you the latest position on the question about burial. This is the famous Ontweka matter. Ontweka versus Ontweka started in the lower court. In the lower court, this was a dispute between a wife and Ontweka's brothers. That is the brothers-in-law. The wife said Ontweka should be buried in Kamulu in Nairobi, Ruai region. The brothers said, the brother to the late, said Ontweka is such a prominent Kisii. He's such a prominent man. He's such a professional and a big name. He must be buried in Kisii County, in a place called Kiango. The argument was that Ontweka had built a house in Kisii, which has 2 doors, which complies with the traditional approach of building a house in Kisii. Equally, Ontweka had built another house in Kamulu with the similar 2 doors. So the question that was before the judges, before the magistrate was, will Ontweka be buried, 1, at Kisii or at Kamulu? 2, who between Ontweka's biological brothers and on one hand, and Ontweka's wife with his children has the power to bury Ontweka? This was a landmark decision. It is a very latest decision. It is a civil appeal number E692 of 2023. The decision came in January 25th, 2024. Is now the current law about burial disputes. This was a case that was filed by the brothers of Ontweka, that is Joseph Ontweka, Elisha Ontweka, Stanley Ontweka, David Ontweka, against the wife or the widow Zipporah Masese Ontweka. This matter went before the following judges. Justice Gashoka, who did the lead judgment, the judge of the Court of Appeal, Justice Lydia Ajode, also a judge of the Court of Appeal, and more fundamental, Justice Francis Tuyot. Francis Tuyot was competing to go to the Supreme Court. He lost to Justice Warsame. What are these 3 judges giving us as the current law about how the judgment should be? It says, it is a very, very interesting judgment. The judgment by Justice Gashoka. He says, despite no one having personal experience with death, All of us have no personal experience with death. We all know that one day we will, all of us, meet our end at some time, at some point. But how? We don't know how. And by whom? We don't know. Our corporal remains will be disposed, remains unknown to us. Who will bury us? How will we be buried? Where shall we be buried? The judge is saying, death is inevitable. Kuzaliwa ni bahati, kufa ni lazima. He moves on to say, in Christian theology, we are all told that Jesus of Nazareth predicted his death, but he did not at all any point prophesy that Joseph Arimathea would inter his body at Golgotha. Fortunately, no burial dispute ensued. Can you imagine if the burial dispute of Jesus arose? The judge is saying, thank God, there was no burial dispute of where Jesus was going to be buried. Paragraph 2. In the Greek mythology, one of the earliest recorded burial disputes is aptly depicted by Sophocles in his work Antigone. He says, and I quote, following the brutal murder of Polynices, Creon, the king of Thebes, prohibits the burial of Polynices. Polynices' sister, Antigone, defies the king and proceeds to bury him. The king has ordered the killing of Polynices and said he cannot be buried. He must be eaten by the dogs. He must rot. He can't be buried. But Polynices' sister, that is Creon, Antigone, defies the king and proceeds to bury him. She then declares to her sister, Ismene, that we have only a limited time to please the living. We have only a limited time to please the living, but an eternity to honor the deceased. We please the living short time, but for the dead, it's an eternity. It is mandatory. We must bury our own. We must bury our relatives. We must bury our family. That is an eternity, an honor of eternity. She says, abiding by the law of the gods. She abided by the law of the gods that you must bury one of yours. But she defies the human law set by Creon. She defied the law of the king. Wow. The poet, Ashoka Justice. I wish he applied to go to the Supreme Court. This could have been his landmark ruling. If this was presented before the JSC by Toyota, I'm telling you, this could have taken Toyota ahead of Warsame. There are burial customs on one side. There is modernity and civilization on another. There are religious church beliefs. There is a battle between the free and the law. Wow. To capital. Constitutionalism has grown over the centuries with the resultant clash between some customary rights and rights of individuals. The law, the constitution, the statutes, vis-a-vis the customs, vis-a-vis modernity, and vis-a-vis the theology, the church. Thus, decisions made regarding the disposal of a body are complex to decide upon and difficult to undo, as human nature frowns on disturbing the remains of the deceased. Remember, nobody wants the deceased to be disturbed. That is why they say, rest in peace. peace. If you joke with a grave, people are mad. If you defame a dead person, people are mad. Thugs, criminals, convicts, rapists, murderers, when they die, they are called, they were heroes on this earth. Nobody in the obituary, nobody in an eulogy can defame a dead person. If you talk ill of a dead person, the society is frowning on you. Not even your enemies. You cannot say bad things to your enemies. That's what the judge is saying. Is this dispute of burial only in Africa? Let us look at a burial dispute in the US. In the case of Louisville versus N.R. Coe and Wilson, in 1905, the U.S. Supreme Court of Georgia, the U.S. Supreme Court of Georgia said, and the law in its all sufficiency must furnish some rule by legislative enactment or analogy, or based on some sound legal principle by which to determine between the living questions of the disposition of the dead and rights surrounding their bodies. In doing this, the courts will not close their eyes to the customs and necessities of civilization in dealing with the dead and in those sentiments connected with the decently disposing of the remains of the departed, which furnish one ground of. So, in 1905, the Supreme Court of America is looking at the conflict between customs, religion, modernity, and the law. Today, all those things are here on the question of death, disposing a dead person. He goes on to say in paragraph 6, turning on the burial dispute that is before us, this is a second appeal from the judgment of the High Court, where Justice Eric Ogola, J., involving the remains of Naftali Onderi Ontweka, who in his lifetime was a senior public servant. The term rest in peace in burial nomenclature connotes that once a deceased joins the afterlife, his or her remains are interred as soon as possible, subject to religious and or customary burial rites, in the hope the departed soul finds peace after death. Remember, on earth we are working. The defense never rests. We don't rest. Even you, I know you don't rest. You're working to get a coin. You're working to fund your family. You're working to educate your children. You don't rest in peace. You sleep, you rest, but you don't rest in peace. The judge is saying you only rest in peace. That is why after death, people want to bury you very fast so that you can rest in peace. The appellants are his brothers. The people fighting are his brothers. Probably this burial dispute is a legal tussle between the wife of the deceased and his brothers. The wife and his children versus his brothers. From what we can discern from the record, during his lifetime, the deceased constructed a family home situated in Kamulu, Mavoko town on a parcel of land measuring 5 acres, which he purchased on 13 September 2005. The respondent, the wife, wants him buried there. The deceased also had a home in Kiango, Kisii, in Kisii County, where the appellants, who are his brothers, want him buried, and another home in Kileleshwa in Nairobi County. He was also building another home in Iyenga in Kisii County on a property measuring 3 acres. As fate would have it, the deceased fell ill and received treatment at Nairobi Hospital. Regrettably, the deceased succumbed to death on 19th April 2023. His body was then transferred to Lee Funeral Home. An obituary in the local dailies on 30th April informed members of the general public that the deceased could be buried on 5th May 2023. The place of burial was not disclosed. So when the deceased died, the brothers put an obituary that they are going to bury their brother. The wife rushed to the magistrate's court and got orders stopping the body from being released to the brothers and to be taken to be buried there. What did the brothers tell the court? The brothers denied their vehemence and said they filed a defense and a counterclaim dated 5th May 2023, and they said they allowed that since the deceased and his family subscribed to Gusii customary law, he ought to be buried based on those cultural rights by his brothers. To the appellant, irrespective of where he acquired property across the country, the burial rights under Gusii customary law ranked the highest. So the brother said, number one, this is a Kisii. He must be buried in Kisii. Just like SM Otieno case, he must be buried in Kisii. Two, by who? By the brothers. Just like the Umira Kagere clan, Siranga was saying, it is me to bury my brother SM Otieno. They urged the trial court to dismiss this case and release the body to go to Kiangobo Machoge, Borabu, Kisii County following the Gusii customary law. What did the magistrate find? The magistrate rendered a judgment on 5th June 2023 and found out that the deceased never professed the Christian faith. Despite his baptism, that he never divorced himself from his patrilineal Gusii traditions, taking note of the fact that he married the respondent under customary law. He married the wife under customary law. He named his children in that law. All these children have Kisii names. 3, he accepted his role as the chairman of the Mugunde family. He was a chairman of a Mugunde family. 4th, and wasn't a member or affiliated to any church. He was not a member of any church. The trial court opined that the deceased and the respondent subscribed to the Gusii customary law, which remained applicable to that fact and circumstances of this case by dint of Section 3(2) of the Judicial Act. Therefore, the court's decision was that there is no way in which an African citizen of Kenya can divest himself of the association with the tribe of his father if these customs are patrilineal. The magistrate ordered the body to be buried in Kisii. Aggrieved with this, the wife, the widow, rushed to the High Court and filed the petition. Paragraph 17 says, for those reasons, the trial court dismissed the plaintiff's suit and allowed the counterclaim, which, aggrieved by those findings, the wife filed a notice of appeal on 12th July 2023 in the High Court, Family Division, Nairobi. And the High Court was before Justice Eric Ogola, the court. The learned judge looked at this question, and the learned judge referred to the judgment of the former Chief Justice, Justice Maraga, David Kenani Maraga, currently now the presidential candidate to be the president of the Republic of Kenya. When he was a judge, he made a decision. Remember, Maraga is a Kisii. What did Maraga, Justice Maraga, in the case of Oliver Bonareri Omoi and 5 others versus Joseph Basweti Orogo in 2010, Justice Maraga said, does Kisii customary law provide for burial disputes like the one in this case? Maraga said yes, it does. Under Kisii customary law, the widow or widower has a right to bury his or her deceased spouse. It follows that the respondent in this case has a right to bury the deceased. That right is, however, not absolute. The deceased's view as to where and who should bury his or her body as well as other circumstances, do in most cases override that right. It is common knowledge that I take judicial notice of the fact that a reasonable fraction of cases have moved out of Gusiland and settled in other parts of the country. Except in cases of ownership disputes, nearly all of them are buried in their new acquired home when they die. So, Ogola went to Justice Maraga, and Justice Maraga in 2010 had said, you can be buried as a Kisi anywhere where you have bought land. Ogola reversed the decision of the High Court and ordered that the body of Ontweka be buried by the wife in Kamulu. Kamulu is in Cumberland in Nairobi. And the judge gave this quotation. Listen to what Justice Ogora said. The nuclear family is the basic unit of the family, which is recognized and protected by the state. The core and basic unit of a family is the nuclear family. This means that the basic unit of the family has rights that should be recognized and upheld by the state. In this case, the appellant's family begins with the basic unit, and the nuclear family of the deceased has the right to bury the deceased unless exceptional circumstances arise to render the nuclear family undeserving of burying the deceased. With that in mind, I declare that the appellant, that is the wife, the widow, has the right to bury the deceased. Ogola said he changed from SM Otieno position, that the family has the right to bury one of their own, not the wife. Ogola went to Article 45 of the Constitution and said it is the wife and the children. This was a dramatic departure from any other justice that has been issued. The brothers, aggrieved, they went to the Court of Appeal. Aggrieved by that judgment of Justice Ogola, they filed a notice of appeal on the 6th of July 2023 and a memorandum of appeal dated 24th August 2023. So they are challenging Ogola's finding that the wife, the widow, should get this judgment. They should bury their brother. This is a similar case like the case we are seeing in South Africa. A dispute between customs, the family, and the state. President Lungu retired, lost an election. He was the president of Zambia for 10 years. He lost. The family want him buried in a private place of their choice. The government is saying, and they are also quoting the customs, that the customs demand he be buried at home with the family. The government is saying this is a public former president. In South Africa, the decision was that the burial of a public figure overrides the interest of a state. The three judges looked at the case of Ruth Wanjiru Njoroge versus Jeremiah Njeri Njoroge in 2004. What does the judge say? The person who is first in line of duty in relation to the burial of any deceased person is the one who is closest to the deceased in legal terms. And as the marital union is the closest chain of relationship touching on the deceased, therefore, it is only natural that the one who can prove his fundamental proximity to the deceased has the right of burial ahead of any other claimant. In 2004, the judges changed the law from the brothers, from the clan, to the question, who is very close to the deceased? Is it a wife? Is it his children? Or is it brothers? Remember the theological, biblical teaching. A man shall leave his family and get married, and the two shall be one. Did Onderi leave his brothers? He must have left his brothers. Did he leave his family? Biological? Yes. Did he marry the wife? Yes. Did he produce children? Yes. In 204, the jurisprudence is changing from SM Otieno, where culture is superior. In 204, the jurisprudence is changing that you must show proximity, very close proximity to the deceased. So the question the judges are saying, yes, you might be a wife, but do you know being a wife does not give you the right to marry? You might be a wife by virtue of a marriage certificate, but you separated with your husband. You went away. You differed. You have never been close. This person has been close with another woman. This person has another lady who they have been close with. And this lady, they are not married to. So you must prove that you are close, not only that you are married. That is what the development of the law in this matter. 2, if you are a drunkard, if you are useless, can the court give you the power to bury your wife, bury your husband? Some husbands are drunkards. Some husbands are useless. They can't do anything. Can the court give you the power to bury somebody when you are a useless, a nincompoop, an idiot, a man, a woman who can't exercise any right? This was a question in paragraph 55 in Barrows versus HM Corona for Preston and another in 208 in Great Britain. The court denied the deceased the right to bury her son because she was addicted to heroin despite ranking first in the order of priority. The court held this. Whatever her good intentions, which she expressed in her evidence, I do not doubt that as a result of this addiction, she is incapable of handling the funeral arrangement. Her sister, Mrs. Jones, obviously from her evidence, she's a capable woman, considered that Miss Jones would be able to carry out the funeral arrangements. As she said, she would, but she has no independent claim to do it. So the law is developing. You might be the wife. You might be the brother. You might be the father. You might be the mother. The deceased is your son. But you are practically incapable. We have seen families where the firstborn is useless. The secondborn is a drunkard. A lastborn is allowed to bury a father. We have seen families where sons are drunkards and they are useless. Daughters have been given the power by courts to bury their parents. So the court is looking at, are you able to bury? Leave alone your entitlement. The law is developing. The religion. Today, the church where somebody goes is a critical element on death. Actually, customs are dying. The church doctrine, the church teaching where the person was going has overtaken customs. People are now being buried based on what the church is saying. If one is a Catholic, he'll be buried as per the Catholic wishes. If one is an SDA, they will follow the SDA doctrine. If one is an Anglican, if one is a PAG, if one is a PA, all of this is the development of the law. Paragraph 59, which everybody must listen, and Cyrus is listening, and Cyrus is shocked. Vivian cannot believe it. The judges are saying, the elephant in the room In paragraph 59, the elephant in the room is who has the right to bury the deceased and which place. No case is on all faults with another, and each case is determined by the particular circumstances and the evidence that is adduced at the trial. In this appeal, we have a deceased who constructed 2 houses in 2 different places, and the evidence on record shows that both had 2 doors in line with the Gusii customary go. Paragraph 61, the judges are saying, we agree with the High Court that the interest of the nuclear family ought to be respected. I disapprove of customs edicts that supersede the natural and the paramount unit of society safeguarded under Article 45 of the Constitution. Without family, there cannot be customs and social norms. There must be a good reason why the Constitution embodies the family as the natural and fundamental unit of society and the necessary basis of social order. Indeed, the connotation of the family as a natural unit of society finds its basis in philosophical and the jurisprudential school of natural law as espoused by John Locke and other philosophers. As John Locke put it, this is a philosopher of law. Natural law is law before the existence of society, and therefore a deviation from it in preference for legal positivism would not augur well with society. So the judges, what did the judges provide? The judges looked at this and said, in applying customary law, one must appreciate the living nature of customary law. Very fundamental. Is customary law static? The law we saw in SM Otieno is static. The judges found out in paragraph 68 that the true nature of customary law is a living body of law, active and dynamic, with an inherent capacity to evolve in keeping with the changing lives of the people whom it governs. Our history, however, is replete with instances in which customary law was not given the necessary space to evolve, but was instead fossilized and stonewalled through codification, which distorted its mutable nature and subverted its The coming of the Constitution is designed to reverse this trend and to facilitate the preservation and the evolution of customary law as a legal system that conforms with the provisions. The judges are saying customary law changes with the technology, with the time. The customary law that our grandfathers used cannot be the customary law applicable today. A Gen Z Mukamba cannot be expected to live under the Kamba customs of 1920. A Gen Z Kisi cannot be living as a Kisi of those years. So the law, according to the judges, the Constitution has given power for customs and traditions to evolve according with the time. They proceed to say customary law must be permitted to develop, and the inquiry must be rooted in the contemporary practices of the community in this issue. So the society must change. You cannot tell these people to do things as they go. It moves on to say, the law only recognizes the persons who are closest to this. And therefore, he gives an example. In 1974, a Gusii school teacher who lived in a town decided to build his house in the rural area of a pleasantly situated spot within the paternal homestead. When his blind grandfather, the father was blind, who was head of the homestead, was told that the house has been built, he called his grandson and told him that the spot was not a suitable house site because the ground there was solid rock and would not permit the digging of a grave in which he could be properly be buried. So the grandfather looked at a place where his grandchild will be built based on, is it rocky? Can a grave be built there? So have you built your home on top of a rock and they will need explosives to break the grave for you to be buried? So the judges proceeded, and this is the decision of Ontweka. He says, from the above excerpt, I understand it to mean that the people of Gusii are buried where they set up their homestead. It need not be their paternal homestead, but where they have built a home. That is what he says. That's contrary to the appellant, that the High Court did not rely on extraneous matters when it says that Gusii people have migrated. The final shocker comes in. Paragraph 79. Burial disputes are emotive, and whatever the outcome, some will be left in tears. Some will be left in tears. The judge is emotive. This means that the words and phrases employed in the resolution of a dispute should be sensitive to the mental and physical health of the parties involved in the burial dispute. The judge's tone is slow because he's going to give a shocker. Paragraph 8, the judge has reduced his voice, his tone, and is saying, the problem before me is really insoluble. It is impossible to weigh the competing claims and arrive at what one would really, truly call a legal judgment. I understand and I respect the wishes and beliefs of the parties. There is no solution that will satisfy each side. I can only make a decision and indicate my regret that it will cause pain to the unsuccessful party. The judge is saying, in a burial dispute, because it is a winner takes it all, one party will go crying, not because they have lost a brother or they have lost somebody who is dead, but because they have lost in court. The other party will be celebrating that they have won in court to bury, but they are also mourning that they have lost a relative. Remember, in court, the judge is saying, these are all family people. One is a wife, the others are children, the others are brothers. The judge is remorseful. He goes in section 23, which is the final orders, and says, accordingly, whereas the brothers may understandably be aggrieved and emotionally drained, the law is not on their side. Accordingly, let me repeat, whereas the brothers, the appellants, may be understandably be aggrieved and emotionally drained, the law is not on their side. It is my finding that this appeal lacks merit and is hereby dismissed in its entirety. I uphold the judgment of the High Court and the order that the remains of the deceased will be buried on parcel number, land number block 12/221, Mavoko Town, for the avoidance of doubt. the body of the deceased shall be released to Sipora Masese Ondieki, the respondent. The brothers, the appellants, are at liberty to attend burial and perform the Gusi customary rites. This is the solemn judgment of Justice Kashoka to the brothers. It is devastating. What did the other two judges say? Justice Tuyot, J.A., in paragraph 84, remember Justice Tuyot competed with Justice Wasame and lost to go to the Supreme Court. Judge says, I have read the carefully and detailed draft judgment of my brother Gashoka, J.A., with which I readily agree. In it, my learned brother aptly recounts her Greek mythology, just as Antigone had explained her defiance of the king. The proposed outcome of that draft judgment, while displeasing to the living, while displeasing to Ontweka's brothers, while displeasing to the people of Kiango, while displeasing to the people of Kisii County, it brings honor to Naftali Onderi Ontweka, the deceased. Justice Tuyot, according to him, this judgment brought honor and glory to the deceased Naftali Onderi Ontweka. In the end, and as Justice Ajode, what did Justice Ajode say? In paragraph 87, I have had the advantage of reading in the draft of the judgment of Honorable Justice Gashoka. I'm in full agreement with his reasoning and conclusion, and therefore have nothing useful to add. Dated and delivered in Nairobi, this 25th day of January 2024, by Justice Gashoka, Court of Appeal Judge, Justice Francis Tuyot, Judge of the Court of Appeal, and Justice Lydia Jode, Judge of the Court of Appeal. It's a very sorrowful day. But what are the lessons from this? Court of Appeal decision. What is the lesson learned from court helicopter? There is no property in a dead body. 2, if there is no property for a dead body, let the wives bury the man they lived together. The decision of where to bury by law now is on the wife. Remember, most marriages are broken because of intrusion by the mothers-in-law. They don't want their son and their daughters to live and make decisions. We shall be dealing with the law on divorce. Intrusion by third parties, the law is frowning on it. The clan, the society, the law has moved away from you. You want to bury a man who has never come home. When did your Gen Z people come home? When did they live in the village? How many know the language where they come from? You are calling them Kisses. You are calling them Kambas. You are calling them Mijikenda. You are calling Luos. Are they Luos by practice? The judges are saying these people are, when they die, they are no longer bound by the customs of where they didn't go. These people, the person they know is their wife. The person they know is their husband. Young men have married in Nairobi. They have bought land in Karen. They have bought land in Kitengela. They have built there. They want to bury their wives. They want to bury their husbands where they are going. Customs. You've lost it. On burial, customs, you've lost it. The courts have moved away from the SM Otieno matter. Justice Bosire's decision is no longer applicable under the law now. This is the current law. We have brought it to you. It's a 2024 matter. This is the current law about burial. The question the judges are talking in low tone, is it necessary to waste time from the magistrate's court to the high court to the Supreme Court? Lawyers are eating your money. The reason why Article 159 is there is that family disputes, people should resolve this matter quietly. Before you go to court, leave, discuss at home. The longest burial dispute in Kenya was over no SPD at Central Police Station. It took 8 years from when he died. He was kept in the mortuary for 8 years. That is when a decision was arrived at to bury that person. Why will you want to marry to be in the mortuary for 10 years? Why will you want your father? Why will you want your son? Why will you want your brother? Why will you want your wife? Why will you want your sister? Why will you want anybody to be in the mortuary? That the case is proceeding. There is no dispute where the body is going to be buried. The dispute is who is going to be buried that person. Is he going to wake up? Whether you bury him? Whether you are the one clothing him? What value do you get that you buried this person? Whether that person is buried at Langata Cemetery, whether he's buried in Nyamira, whether he's buried in Makueni, is it lawful to keep somebody in a mortuary for 5-7 years? From court helicopter, out of 10, we give 0 for those ones who take burial disputes to court. 0 out of 10. For those ones who sit and resolve this matter, we give them out of 10. 10 out of 10. Now you know the law. Parents, you have no right to bury your married son. You have no right. It is the wife who has the right to bury their husbands. Parents, you have no right to bury your daughter-in-law or your daughter. That right is left to the husband. That right is left to the wife. This is a landmark ruling. And I hope you now know there is no law to Parliament. To Parliament, we give them 0 out of 10. They have not made the law. We are calling upon Parliament to enact the law on burial and codify Ontweka versus Ontweka. May the family under Article 45 of the Constitution grow and develop. Rigid customs, Rigid traditions are overtaken by events. Barbaric cultures forcing young men, young people to follow customs that are repugnant to morality. The Court of Appeal has pronounced itself. Wakili Dan Senomari giving it to you as it comes. The law is settled now through Ontweka and Ontweka on who has the right to bury. And for those women who are married and have run away, they are not there to take care of their husbands. Don't think you'll come and say, this is my husband. The law can give any other person the right to bury. If there's a woman who was taking care of your husband when you were not there, she will be given the right to bury that person. This is the position of the Court of Appeal. It is not marriage. It is who is close to the person who died. Who was there when this person was going to hospital, when this person was suffering, who was cooking for this person, who was giving this person medicine, who was ironing this person, who was washing him when he was incapacitated. That is the person who will be given the right to bury. Will concubines have rights to bury? Yes. If they are the ones who are proximate, very close to the deceased. Will the children have a right to say where their father or mother is going to be buried? Yes. The proximate, close person to the deceased is the concept. Wewe kaa tu, bibi kaa nyumbani, kataa kuchunga bwanako. Kuna mwanamke na amezaa mtoto na watoto wa na yeye, they will be given the body to bury. Produce a marriage certificate, you will lose. The law has moved away from what you thought about. Wasame said, being married is no guarantee to owning properties or marriage. We are now telling you, being married with a certificate is no guarantee to bury your husband. It is the person who is close to bury their person. Wakili Dan Senomari giving to you the controversial position of Ontweka versus Ontweka.